Agenda for the business meeting is public hearing concerning the zone text amendment, Chapter 1225, the codified ordinances pertaining to housing architectural standards. Mr. Kohler?
Good evening. This item pertains to a piece of legislation on your agenda amending the chapter regarding architectural standards for new residential construction. This chapter was adopted in 2002 and pertains to all new housing construction being single family through four family. In the course of reviewing plans over the last few years, we've noted that we've run into problems with four specific standards that we're trying to address by this piece of legislation. First of these, next slide please, is pertaining to average building height. The current standard says that no two residential structures can be more than 10% difference in height within a single block. What we're finding out, though, is that if someone wants to build a ranch house next to a two-story house, we're bumping up against a problem with this standard. I don't believe it was the intent that when a block is developed that they all be two-story or all be one floor, and that would probably make for a fairly boring streetscape. Our suggestion is to amend that section to allow for up to a 40% discrepancy, which deals with almost every situation of having a ranch house next to a two-floor house. The second amendment is regarding the allowable landscape area in the front yard. Our current requirement says that 15% of the front yard area has to be in mulched beds with landscaping. Where this becomes a particular problem is on large corner lots where you have double frontages or extra wide lots. It requires a tremendous amount of landscaping as opposed to a single lot within a block face. So the recommendation is to amend that standard to make it 15% of only the minimum required front yard for a lot in that zone. And that basically levels the playing field for the amount of landscaping that any particular building would have to have. There's an additional amount for corner lots that an additional 10% would be required on those particular corner lots. Third item is the current procedure is that the Architectural Review Board has to approve all new single-family, two-family, three-family, four-family buildings that are built within the city of Middletown. To try to make that as customer-friendly as possible, that board meets every 2 weeks. But what we're finding is now that the local home builders are accustomed to our regulations, virtually every plan that goes before the Architectural Review Board meets 100% of the standards. So it almost becomes a rubber stamp of the Architectural Review Board by the time it gets to that point. The recommendation of both the Architectural Review Board, Planning Commission, and staff is that when these house plans come through and they meet 100% of the architectural standards, that we simply be able to approve those on a staff level and allow the construction to proceed. We're proposing, though, also that the Architectural Review Board remain as a viable board in the case where either something does not meet standards or whether there's an appeal of those particular standards. So they actually would remain as an appeals board. The current situation is that the appeals go to Planning Commission. And what this proposed regulation also does, that if a person feels aggrieved by a decision of the Architectural Review Board, they have a further appeal to the Planning Commission if they feel that the Architectural Review Board has judged in error. And then lastly, because of the Architectural Review Board's previously that the appeals or the variances were granted by Planning Commission, that we bump those abilities to grant variances down to the Architectural Review Board level. What we believe is that this will greatly streamline the city processes. It will greatly expedite the ability of home builders to be able to get projects under construction and probably save a lot of staff and ARB time in the process. Any questions on the amendments?
I don't know whether this is the proper time or not, but I tried to reach you this morning. You were in meetings. There's an issue out at something rather Meadows, which is the subdivision off Brill Boulevard where Martin was building. Okay.
Okay.
Okay. In there, I came across, well, a person contacted me. The deed out there, the deeds read clearly that no sheds are to be built. However, there are sheds out there, and this particular shed that I'm concerned about obstructs, actually, if you're coming down Marguerite, which is the street, Marguerite and Marissa or something, but this person is on Marguerite, and if you turn the corner there, you don't even see the front of his house. There's this big shed that the person on the corner has put to the rear of their property, but also in putting it to the rear of their property, they're putting it in front of the other person's. And I was just wondering, and I understand that the permits were issued, and as they had to be. I understand the permits were issued for these sheds. However, would there not be a way to make those the people in issuing the permits aware that there is in the deed working, there is something there that says that no sheds should be erected. Now, this gentleman has an option. He can take them to court. But who wants to take maybe 20 or 30 of their neighbors to court? Who wants to put themselves in that position? And I'm concerned that when that takes place, when there's that reading in a deed for a subdivision, should not we have some sort of way to stop from issuing these building permits? It's an ugly shed, and it's sitting on blocks.
That is a good question. And actually, that question, though, doesn't pertain particularly to what we've got in front of you. But to answer the question, I am aware of that particular situation in that we do permit garden sheds in rear yards in single-family residential neighborhoods. There are plats all throughout the city that have special regulations dealing with things like swimming pools, basketball goals, sheds, a whole variety of issues that go above and beyond zoning. And every subdivision plat sometimes has their unique standards. If we're aware that there's a complication with something, we typically will inform people. But quite honestly, our staff has not been so involved with all the subdivisions, and there are probably close to 1,000 subdivisions in Middletown, to know all the details of those. We cannot deny a permit based on a covenant of a subdivision.
Okay.
That covenant is a covenant for among the property owners within that development, and it's up to those property owners to see that they're enforced. The city does not have, I guess we would call legal standing, because we're not a property owner in that subdivision, to enforce those regulations. But that is a point that does come up occasionally.
Have you saw the property?
Yes.
I'm wondering, to me, that shed is not setting to the rear of that house so much as it's setting to the side. If it were back against the fence, if it were all the way back and against the fence, that would be the rear of the house.
Yeah,
where it's sitting right now, it's at the side of the house.
Yeah, it has to be behind the rear yard of the house on which the shed is located. In this particular location, the adjacent house, by their choice, chose to build a house much further back from the street than what zoning requires. So in terms of the house next door, it does appear to be in their side yard, almost in their front yard.
Okay, well, I appreciate you taking the time to explain, because I'm sure that person is going to review this, and I'm certain that he's expecting a response of some sort.
We're still reviewing the dimensions just to make sure they're in full compliance, but on initial look at it, unfortunately it sort of opens Pandora's box, so to speak. That particular subdivision we discovered allows no rear yard sheds, allows no fences. That subdivision is full of fences and full of rear yard sheds.
Our house was built 50 years ago, but after I talked to him, I got out my deed and I read it. Who would have read their deed? I didn't read a deed, but I did now. I know now that there's anything there.
Yeah, that's a good caution for people buying houses, is not necessarily what's on the deed, but on the subdivision plat,
right,
which few people, when they buy a house, actually see that subdivision plat and all the terms and conditions that are included on that are not necessarily on their deeds.
Well, this is sort of, really, I feel very bad for the people who who are having to look at the back of that shed. If it were close enough to me, I would paint it. but it isn't. It's a little farther away.
Okay, the issue of the public hearing, of the 5 amendments that Mr. Kohler pointed out, are there any questions or comments concerning the presentation?
No.
No? Thank you. Since this is a public hearing, the public has a right to speak to these issues. If anybody would like to speak in favor of council accepting these amendments? Anybody like to speak in favor of council accepting these amendments as recommended by Planning Commission? Hearing none, would anybody like to speak against council accepting these amendments to change the chapter 1225? Anybody like to speak against?